Earlier this year, the ATF issued a rule that unilaterally puts new restrictions on Second Amendment rights.
The submitted firearm brace, when attached to a firearm, does not convert that weapon to be fired from the shoulder and would not alter the classification.
It's not ruled to be attached as a short-barreled rifle. It will not be subject to the rule.
The Second Amendment to the United States Constitution, Mr. President, as you well know.
When you say that the brace has changed, because your rule affects the braces that didn't change.
These individuals could lose the ability to use these tools, and as a result, may not be able to operate.
ATF has a history of reinterpreting federal law in an attempt to expand what firearms and accessories are illegal.
Breaking news, a nationwide injunction that prohibits the ATS pistol brace rule in its entirety has just been imposed by a federal district court. Nationwide injunction against ATF's pistol brace rule. A major decision against the ATF's pistol brace rule. A nationwide injunction has been issued against the ATF and that pistol brace rule, enjoining the rule in its entirety. This is something everyone has been wanting, and we finally got a nationwide injunction. Is an order that was issued by a judge, Judge Matthew. He just struck down and issued a major injunction against the ATF pistol brace rule. This ruling by Judge Matthew springboarded off the recent decision by Judge R. Connor in the Mock v. Garland pistol brace case. However, in this Bro v. ATF case, the judge went the extra mile and actually granted what was requested, a nationwide injunction, an injunction against the entire pistol brace rule. Again, it's a national injunction. You may recall that in the Mock v. Garland case, the judge also issued an injunction, but the injunction only protected the members of FPC. That was against the pistol brace rule, so it was much more limited. Then they had some other cases like the GOA case and the Nager case, which also got similar results protecting their members. Well, this Bro v. ATF case and the decision here went beyond just protecting the individual plaintiffs. It actually gave an injunction against the entire rule.
You would think the head of the agency tasked with regulating the entire firearms industry.
ATF has a history of reinterpreting federal law in an attempt to expand what firearms and accessories are illegal.
The submitted firearm brace, when attached to a firearm, does not convert that weapon to be fired from the shoulder and would not alter the classification.
Earlier this year, the ATF issued a rule that unilaterally puts new restrictions on Second Amendment rights.
So we need to look at what the order did, and then we need to break down what happens now going forward, because we think there's a lot of commentary and discussion and articles going around right now talking about the decision, but not really giving you guys the full picture about what this order does and really where this case goes from here. Therefore, in order to understand this ruling and its implications, let us first clarify that a preliminary injunction against the ATF and the pistol brace rule has been granted. Preliminary injunctions are a type of temporary relief that lasts only until the case is resolved entirely on the basis of the arguments presented. Therefore, this order prevents the pistol brace rule from being enforced until the case is resolved entirely. If someone claims in an article or discussion that the case has been resolved entirely and that it is finished, that is not necessarily the case. In fact, the case is still ongoing, and we will discuss some of the actions that the ATF is likely to take moving forward. To obtain a preliminary injunction, a party must demonstrate two main requirements. First, a likelihood of success on the merits. Second, irreparable harm in the event that the preliminary relief is not granted. These are the four main things that a plaintiff would need to show in order to get a preliminary injunction, which is a temporary form of relief. The judge was reviewing these in the case to see if the plaintiff met all the requirements in order to get their preliminary injunction against the pistol brace rule.
This rule redefined firearms with stabilizing braces as short-barreled rifles.
And the implementation of your rule, did Congress pass a law? What changed?
There are approximately 40 million firearms with stabilizing braces currently in circulation.
It's not ruled to be attached as a short-barreled rifle. It will not be subject to the rule.
After reviewing the case, the judge found that the plaintiff met all of those requirements, and he granted their preliminary injunction. The judge stated in the decision that this court does not start with a blank slate. Garland provides substantial guidance given the Fifth Circuit's holding. This court recognizes that the rule was not a logical outgrowth of the proposed rule, and must be set aside as unlawful. So that is what he said here. That is what the judge here in the Bro versus ATF case is saying. He's agreeing with the Mock versus Garland case, and he is springboarding off of that decision by Judge Connor and the Fifth Circuit to now issue his own decision, since the Fifth Circuit and Judge O'Connor already found that this rule violates APA. Analysis of Bro versus ATF decision and implications. Because the rule fails under the APA from the outset, he really didn't have to do much work in this decision and is essentially just using a lot of that language to issue his own ruling. He did state that he did not proceed to the Second Amendment violation question and that entire issue, so he doesn't even need to look at the Second Amendment question because the rule kind of just fails at the very beginning. As a result of the Mock decision, the likelihood of success on the marriage factor was automatically transferred to the brittle case and given to the brittle plaintiffs. He then looks at whether each plaintiff will suffer irreversible harm, and naturally he finds that the pistol brace rule will clearly cause harm to each individual plaintiff. He also notes that each plaintiff may have to pay potential compliance costs, such as having to register before the deadline in order to avoid having to turn over the brace pistols, modify them, or destroy them.
Pistol brace was created for use by disabled person, including disabled veteran.
Thank you, Mr. Chairman. Real quick, I find it interesting that my colleagues have no problem with the ATF going outside its boundaries.
Under the new rule, these firearm owners will be required to obtain special registration, surrender or destroy their brace.
That's not for us to regulate. If somebody we wrote the rule to make it easy to comply with.
By the compliance date, or they will face severe criminal penalties.
All of which would be expensive and clearly harm the plaintiffs. Lastly, he looked at the public's best interest and considered whether or not this would harm the government and the public. Based on that consideration, he concluded that the government could not claim that the public or the government would suffer harm because the rule that is being implemented violates the American Psychological Association. He then pretty much goes full Chad and destroys the ATF and this last guideline regarding pistol bracing to wrap up his ruling. He states that the court is not insensitive to the ATF's concerns over arm industry ganship and attempts to circumvent the NASA's restrictions on SBRs. However, the government may not simply posit that the regulation promotes an important interest to justify its regulation. There he is directly quoting Thomas Braun. He goes on to say that, of course, some form of protest can be expected when constitutional rights are allegedly infringed. The passage of time and the development of new technology can also reveal latent ambiguities in a statute. Likewise, the court is certainly sympathetic to the ATF's concerns over public safety in the wake of tragic slayings.
Turns law-abiding gun owners into felons is a result of unelected bureaucrats simply enacting a new regulation.
So you say that the brace changed, and so you had to implement this rule.
And that's not how it's supposed to work in our great country. Congress writes the laws and the executive branch enforces them.
Okay, reclaiming my time because it's pretty obvious you're misleading people here.
Your right to own a gun can also be restricted.
The rule embodies solo policy goals meant to protect vulnerable people in our society, but public safety concerns must be addressed in ways that are lawful. This rule is not. And he says for the foregoing reasons, the court grants the motion and stays the rule in its entirety. So the judge granted the preliminary injunction, striking down the pistol-based rule in its entirety. Now you may be asking, what does this mean for you and what does this mean going forward? Well, the decision does halt the rule nationwide for everyone, not just members of organizations like FBC, GOA, and R. This is an injunction against the entire rule. However, we do want to warn everyone that this is a nationwide injunction, but it's likely not going to stand for very long. First and foremost, we know that the ATF is going to appeal that ruling and also seek an emergency state of this decision to the Fifth Circuit. They might have already done that by the time we release this video, so the tradition is that the ATF will appeal this. We know they're going to appeal it, and they're going to seek a stay of this decision. If the Fifth Circuit doesn't grant that emergency stay and doesn't do it fast, then the ATF will go to the Supreme Court once again.
Except with the ATF, they don't even claim to be experts.
The Second Amendment to the United States Constitution, Mr. President, as you well know.
I believe it's a statutory maximum of 10 years.
10 years for owning a piece of plastic?
Last week in a hearing in front of Congress in the Appropriations Committee, he was asked about firearms. He said, I'm not an expert in firearms.
When you say that the braces changed, because your rule affects the braces that didn't change.
The Supreme Court has recently overruled a nationwide vacatur of the frames and receivers rule in the Vanderstock ATF's frames and receivers case, which was a nationwide vacatur. The ATF has already been successful in getting the Supreme Court to grant stays on nationwide vacatures and halting limited injunctions against the frames and receivers rule. The ATF is likely to try to do the same with this national injunction on the pistol brace rule.
They do not have to register anything. They can keep the brace, they can keep the business end of the gun.
These individuals could lose the ability to use these tools and as a result may not be able to operate. Congress didn't change the law. No bill was introduced in this committee.
That you were told was legal and that you owned for a decade and that millions of people did?
The Supreme Court recently took review of the Carrillo bump stock case, and the ATF may seek an appeal from the First Circuit to seek an emergency stay. They may also try to put many cases on hold due to the Carrillo decision, which is currently set to be issued at some point. If the ATF wants to stop the bleeding in the Fifth Circuit, they might try to put a hold on all cases like they did with Braun. The hope is that the nationwide injunction will stay in place, but it could hurt arms stores and companies who want to continue selling braced pistols. Many companies and arms stores are excited to be able to sell braced pistols again. However, there can be drastic changes in the next week or so. The question now is whether the nationwide injunction will stand and not be stayed by either the Fifth Circuit or the Supreme Court. That's all for this video, folks. We'll see you next time.